It's my pleasure to welcome you to our panel discussion this afternoon. I want to begin by announcing the very good news that this will be a PowerPoint-free panel. No PowerPoint presentations for at least the next hour. I also wanted to take a moment to thank the organizers, Paul and Rocco and everyone else. This conference has a special place in my heart. It was a little more than 20 years ago in the United States that we organized the first conference on computers, freedom, and privacy. We had at that time very strong views about privacy and about freedom, but we also believed it was important to promote a public dialogue, to encourage many viewpoints, and to enable the type of public discussion that makes possible better policy. Paul and Rocco have carried forward this tradition, added much better parties and side events than we could ever organize, to their credit. And it is really a fantastic conference, and it's wonderful to be here. Our panel discussion this afternoon begins to explore the dialogue between the EU and the US about the future of privacy protection. And I don't think it's overstatement to say that this is one of the most important issues facing our two great regions. It is certainly on the minds of users of new technologies. It is on the minds of companies, innovators, policymakers, and just about everyone else. And so we're fortunate today to have a discussion that will provide the opportunity to get these unique perspectives on this particular issue. This first panel discussion will look at the consumer dimension. The panel discussion that follows will look at the civil liberties dimension. Both of these panels, in fact, are sponsored by the Conference on Computers, Freedom, and Privacy, which this year will be held in Washington, D.C. at the end of June, and we hope that many of you will be able to join us for that. I'm going to begin by introducing our first speaker. She is Commissioner Julie Brill with the U.S. Federal Trade Commission, a leading consumer advocate, consumer official with a long career in the field of consumer protection. And I wanted to thank you, Commissioner Brill, for being with us today.
Sure. Thank you. I actually am very, very pleased to be here, and I want to thank the conference organizers for squeezing me into the schedule. This is such an important issue and such a big issue for both the United States government and in particular the Federal Trade Commission. I thought I would take literally 30 seconds to explain what the Federal Trade Commission is for those of you who may not realize what we do. I was actually asked to do that. The Federal Trade Commission is an independent agency. While I was appointed or nominated by President Obama, I was confirmed by the Senate. All of my fellow commissioners, there are 5 of us, are all confirmed by the U.S. Senate. And we serve for a term of years that is independent of the administration. So we are an organization of about 1,100 employees, over half of them attorneys, that is independent of the administration. We focus not just on privacy issues, we focus very broadly on competition and consumer protection. We are the nation's premier, the U.S. nation's premier consumer protection agency, and coupled with the Department of Justice, we're the premier competition enforcement agency. And that's what we do first and foremost, is law enforcement. We do it we cover broad swaths of the economy, but one of the areas where we've been particularly aggressive lately and particularly focused is doing law enforcement in the privacy realm. But before I get to that, let me describe briefly, focusing now on privacy issues, what it is that we're doing in terms of some of our policy initiatives, and then I'll get to law enforcement. So in terms of policy initiatives, about 10 months ago, we issued a privacy report which established our ideas about a new framework for approaching privacy in the United States. It is designed not to be a law enforcement document, but it's designed to help guide Congress, policymakers, and others in terms of how to think about privacy issues in this new technological age. And it's been a very influential document coupled with the administration's white paper, which I know John will describe, in terms of trying to bring the privacy regulatory realm into, as I said, the sort of modern age by talking about new ideas that we need to be approaching to deal with new technology. But some of the things that we've also done are drilling down into particular areas that have presented unique challenges in the privacy space. So, for instance, we just updated our children's online privacy protection rule, which deals again with some new technological developments with respect to apps, with respect to plugins, and with respect to other technologies in terms of how those types of entities and their sponsors that are bringing them forward in terms of children's programming, whether it's online or in the mobile space, how they will comply with the rule that we have, actually a law that we have in the United States that requires that parents be notified when information is collected about children and that they're able to consent with respect to that collection. So that's been a huge effort on our part, and we've had a lot of discussions with a lot of different entities. I do think we struck the right balance, but it wasn't an easy process by any means. We're also looking at data brokers. Data brokers is an area that we highlighted in our privacy report as one that we will be focusing on in the future, and we have issued detailed requests for information from a sampling of data brokers that are dealing with different types of profiling, credit reporting, risk analysis, and other areas that fall under the data broker umbrella. And we're seeking information about where they get their information, who they provide it to, and how they get information to consumers about their practices and to what extent they give consumers choices about their practices. So we're doing a lot of work with respect to data brokers. Another area that we're going to be highlighting going forward is mobile. Mobile is a big, important issue, and particularly apps. And transparency of the practices relating to data collection and use by apps will be an area that we'll be focusing on greatly in the future. Do not track, very important area for us. I think we were the first government agency, at least in the United States, that called for a comprehensive do not track system. I'll let, Peter Swire is here, who is currently leading the W3C effort. I'll let him describe further what W3C is doing, but there are a number of different developments with respect to do not track in the United States, and we're working with lots of the stakeholders to try to develop as robust a system as we can. But let me talk, if I can, for a moment more. Mark, do I have a moment more? To talk about enforcement, because as I said when I began, we are first and foremost a law enforcement agency. We enforce the EU-US Safe Harbor, and we have brought actions against both Google and Facebook, as well as MySpace and 10 other companies, because we believed they were not living up to their safe harbor agreements. We now have both Google and Facebook under consent orders that last for 20 years that require them to comply with the safe harbor, and if they fail to do so, they will be penalized. In addition, those orders obviously cover lots of other issues with respect to both Google and Facebook, and as you may know, we've actually enforced the Google order with respect to Google's practices involving Safari. But those are the enforcement cases that kind of get the headlines and probably get a lot of attention. We have brought many cases involving lots of different players in the data collection and use ecosystem. So credit reporting agencies, we've brought cases against them. We've also brought cases against entities that we believed come under the Fair Credit Reporting Act because they're collecting information that is then used for employment, insurance, housing, or credit, but they didn't comply with the Fair Credit Reporting Act. So that's going to be a big effort of ours going forward, is to make sure that entities that fall within that space actually comply with that law. But we have orders out or settlements with ad networks, apps, analytic companies, data brokers, software developers, and of course social media, the big companies that everybody knows about. That is our bread and butter. That is what we do first and foremost. And right now with some of our big orders, we are protecting over 1 billion people around the world, both in the United States but elsewhere with respect to some of these larger companies. So I think that probably does it for an intro of what we're doing.
Great, thank you, Julie. We'll go immediately to John Morris, who's the acting administrator and and director for Internet Policy at the NTIA, which is Department of Commerce. Nice to have you here, John.
Great. Thanks, Mark. So just to kind of confuse matters and try to differentiate between what Julie just described, which is the Federal Trade Commission, an independent enforcement agency in the United States. My organization is part of the U.S. Department of Commerce, so it's part of the administration. And my agency is not at all a regulatory agency. We have no ability to investigate and bring charges against companies. But what we do have the ability to do is to convene people, and that's one thing I'll describe briefly. And we are designated by statute in the United States as the primary advisor to the President on information and telecom policy. So we really do try to kind of address and tackle the whole range of issues, including consumer privacy. Our office was very involved in the consumer privacy blueprint that the White House released last February, and that really had 4 core elements. It had a consumer privacy bill of rights, which is a set of rights based on the FIPS, the Fair Information Practice Principles that are very familiar and form the foundation of much of Europe's work on privacy. And then building on the Consumer Privacy Bill of Rights, we have started a set of multi-stakeholder convenings that I'll describe in just a moment. The other elements of the blueprint do include baseline privacy legislation, something that we're working on and in conversations with our Congress on. And just a couple days ago, the chairman of the House of Representatives Commerce Committee announced that he did put privacy legislation on the agenda for this year. So it's something that both the Senate and the House are going to be looking at. And I mean, the fourth prong of the Consumer Privacy Blueprint is to work on interoperability with Europe and with our other partners in Asia and elsewhere. So those are kind of that's the broad brush. My office has been very involved in implementing the multi-stakeholder convenings on consumer privacy. The idea is to bring industry and civil society and academics and government together to discuss particular issues and to work out codes of conduct that then, once they are worked out and agreed upon and companies commit to doing them, then Julie Brill's, the Federal Trade Commission, would be able to enforce the codes of conduct. So in a way, they feed into the very active enforcement activities that the FTC is able to do. And I'm sure you'll hear from Susan Grant, who's one of the participants in our process. It's been going on since July, I think, is the first meeting, and it's been I think probably a frustrating process for some to really get started, but the stakeholders really have taken ownership of the issue. We picked an issue, mobile application transparency, which frankly is a fairly narrow issue, and we picked it in part to be narrow for the first set of code of conduct development, just so we can kind of work out the kinks in the process. But I mean, in the last few months, the stakeholders have really come together, I think, very, very well, and are hammering out details and detailed language of a code of conduct. And certainly, I don't want to predict success, but I think we're heading in the right direction, and I'm really optimistic that it will form the foundation of, not only a good code of conduct for mobile app transparency, but really the starting point of a number of codes of conduct. Already the stakeholders have agreed that once we finish the transparency focused code of conduct, that we will move on to the other elements of the FIPS in the mobile application space. So it's an area that I'm really quite pleased with the collaboration. Not without its bumps, and I'm sure we'll hear about some bumps, but I'm really very pleased with the collaboration that the mobile app transparency stakeholder process has had, and I'd be happy to discuss it further.
Great. Thank you very much, John. We'll go next to Susan Grant with the Consumer Federation of America. Susan is one of the leading consumer advocates in the United States. Nice to have you here.
Thank you very much. They seated me next to John so he could kick me under the table if I say anything bad about the multi-stakeholder. Right. So Consumer Federation of America is an association of some 300 consumer groups in the United States. We obviously represent, therefore, a very large constituency. I'm really pleased that Julie Brill from the Federal Trade Commission was able to join us because she is a real privacy champion. And with her leadership and others at the Federal Trade Commission, David Vladeck, who until recently was the chief of the Public Protection Bureau, they have really done all that they could do with the authority that the Federal Trade Commission has, which is somewhat limited in that it can't, for instance, promulgate regulations very easily without a statute on something specifically directing it to do so. So, for instance, the Children's Online Privacy Protection Act rules were promulgated under a law that directed the FTC to do that, and they were recently updated and contain some very important new elements, such as a recognition that a persistent identifier is personal information. So we applaud the FTC for all that it does. And I would also like to say how much I respect and admire John and his colleagues at the NTIA, and I know they're trying to do their best with the multi-stakeholder process. But I'm not just going to talk about bumps. I want to talk about what I think are some fundamental problems with that. As you probably know, we don't have a comprehensive privacy law in the U.S. We have a very limited number of narrow sectoral laws with lots of gaps in between. So one of my most basic problems with the multi-stakeholder process is that I think that it's really an abdication of the administration's responsibility to enact laws and regulations in order to make a comprehensive public policy on privacy in the United States. I think that multi-stakeholder convenings of various kinds can be very valuable. I've convened them myself to develop best practices for businesses in some areas, and I've participated in others that people have convened. But I think that the problem here is that we're starting out without even any basic definitions for things like what's personal data, what's a third party and a first party. And so when, for instance, we try to talk about code of conduct for mobile app transparency, transparency for what? We don't have the definitions, and we can't amongst the stakeholders agree on the definitions. So what we've ended up doing, because everybody sincerely wants to come out with something here for various reasons, we've tried to skirt a lot of the issues. And I think what we're probably going to come out with is a very high-level set of principles for mobile app providers it would be good if they provide transparency and some model screens for mobile devices, suggestions on how you can convey information about data collection and data sharing. I don't think we're even going to tackle providing disclosure about data use, because I don't think we're going to be able to agree to that. It's just way too contentious. So we're going to come out, I predict, with something very modest. And it might be helpful to consumers and businesses. That's the reason I'm participating. But I don't think that it's going to have a major impact on really revealing to consumers what's going on very well, and in having any effect on the data practices themselves. And I think the only thing that can do that, frankly, is legislation. Why this is important to Europe is because things like this are being presented to the Parliament and other policymakers here as being equivalent to and adequate for the transfer of data from European consumers to the U.S. And nothing could be farther from the truth. While I think that self-regulatory programs of various kinds can be helpful in different ways, they are not a substitute for having a legal framework that is enforceable by consumers. It's a false representation, in my view, to tell the Europeans that it's okay with what we have. It's equivalent to what you have, so don't worry about your consumers' data. And just one more point, if I may, about the Consumer Privacy Bill of Rights, which is not a bill. It's a piece of paper with some principles, and they're nice principles, and we actually said nice things about them when it came out. But the administration also committed to legislation. It's been nearly a year. We haven't seen it. We asked to be consulted on drafts of legislation. We haven't been. We have no idea what's going to come out. And I really don't think that the administration has fully committed to put its weight behind actually getting legislation through. And if it doesn't, then I think that Europeans are very right to question whether their citizens' status should be transferred to U.S. companies.
Well, it sounds like we have a debate brewing on this panel. You've heard about U.S. Enforcement Authority at the Federal Trade Commission, and you've heard about the multi-stakeholder process at the Department of Commerce, and now you've heard from a leading consumer advocate. We're going to turn next to Peter Swire, who's had a long history in U.S. privacy law and development, having worked in the Clinton administration as a privacy counselor, and he's currently co-chairing the Do Not Track Task Force. How does it look to you, Peter?
Thanks, Mark. If I've been here for a long time, Mark was teaching me things when I came into the field. So we have a great global leader in civil society and data protection here as our chair. For me, it's a pleasure to be here in Brussels again. I was a student at l'Université Libre de Bruxelles, il y a 30 ans maintenant, a long time ago. And I thought I'd talk briefly about my perspectives on the safe harbor as someone who was part of the negotiations of that, and then I will talk about the do not track process. So when the 95 directive was issued, there was very big concerns in Europe and the United States how we would get along. Europe at that point wanted to have comprehensive privacy legislation passed in the United States. The United States said, we don't really think we can get that through Congress, and so we really cannot expect to get legislation in the United States. And now we flash forward to today, 2013. It seems very similar, right? There's this new proposal for the regulation, and then they're saying to the US, why don't you please pass legislation? And it's very difficult, as you've seen, for the US Congress to pass even the things it has to pass, basic budget things. And it's even harder for it to pass things where there's disagreements, such as data protection. So we can hope for that, but I think at a practical level, it's hard to plan on Congress passing that legislation. So we were in that position before. We were in that position in the late 1990s. And the safe harbor is what emerged out of those discussions. And at the time, there were people very critical of safe harbor. From the European Union side, there was a feeling that we were going below the standard of fundamental rights, that the safe harbor was far too weak. It did not cover all the things that a regime has to cover. So there's great disappointment from some of the data protection authorities and others in Europe. There was also great disappointment from many in the US who thought that the US business community was being brought into a European-style regime when there was no basis for that. They thought it was the wrong way to go. And there were very angry statements by industry about how unworkable the safe harbor would be. So what happened? The safe harbor was signed. And this many years later, thousands of companies and almost all of the major companies that do data, except in financial services, have signed the safe harbor. They promise to follow the safe harbor principles, and if they break their promise, Commissioner Brill can bring enforcement actions against them. And you've heard that they've done that. So it was disappointing for Europe, it was disappointing for the United States, but it actually has created, in my view, a workable structure where basic data protection principles have been built into the structures of global companies, and they've made business promises to do that, and they've created compliance systems to do that, and it's created a way to be interoperable that without that would have been much more difficult to achieve. So for all of the problems with safe harbor that many of you in the room are familiar with, it also was a convenient way to continue this process of improving standards while also having global business happen. So that's my perspective. Of course, I was involved in helping to work on it, so I'm a little more favorable towards it. But the fact that thousands of major companies have signed on to it is, I think, useful to think about as we face this second round of EU and US differences on data protection. Let me talk a little bit about the World Wide Web Consortium, which is who's hired me for this. Just as a question, how many people here have heard or read about the World Wide Web Consortium before today? What a well-educated audience you are. I was going to ask next, which of you have ever heard of HTML, like in your browser, okay? W3C are the folks who brought you HTML, okay? They do a global standards operation. They try to have standards for the web. And so the idea for Do Not Track is maybe we can build into our standards for how the web works some way to signal user preferences about tracking, whatever it is quite the tracking means. The W3C has a range of people who show up at its meetings or show up on the phone calls every Wednesday, where we have over 100 member groups represented for these Wednesday calls. The browser companies are there. That's important when you're doing the web because people use browsers for them. Websites are there. Civil society and NGOs are there in quite substantial numbers. And then sort of later to the party, the advertising associations are now all there also. They've realized this matters to them as they do their advertising things. So we have quite a range of people in the room or on the phone, and that includes quite a number of EU individuals, people including from data protection authorities, from organizations in Europe, technical experts of various sorts. What's being done and what can come out of it? Well, for me, Do Not Track comes out of some of the problems, the technical problems with our current solutions for cookies, especially as they're on the web. So there have been regimes in the US for the last more than 10 years where you can opt out, you can choose and say, I don't want to be tracked this way for this advertising network. I don't want you to gather data in certain ways about my activities. And then you have what's called an opt-out cookie, which is a little thing that goes into your web browser that says to people, I've decided not to have double-click follow me here. There's a problem technically with this. On Monday, you decide you want to exercise user choice and you put in your opt-out cookie. On Tuesday, you're going to be very careful, so you decide to delete all your cookies. And now you're feeling really happy about that. You have deleted your opt-out cookie. That's gone. And now on Wednesday, they're tracking you again. This is not a perfect mechanism. It's not a great exercise at a technical level of the user choice. And also, there's other things besides traditional cookies that are used on the web. So the idea of Do Not Track is instead in the browser discussion that goes back and forth, you would have a signal. The signal would be DNT, Do Not Track equals 1. And that's your opt-out cookie, not just for one advertiser, but for all of the people who count for tracking. And if we could do that, you'd have a one-choice, persistent, technical measure, widely understood across the world that that's what you decided to do. That's what we're trying to do. I don't know where we'll get on all that. I was just asked in at the end of November to work on it. But we're having very intensive meetings to try to build that. And the choice also could be highly relevant, for instance, for some specific things that Europe faces. So the e-privacy directive, the cookie directive, there's a question of how users can signal that they would like to have personalization for some purposes. They might want to opt in some cases for things, show their consent. So there's a global considerations group of do not track. The idea here is you could do a setting of DNT equals 0, and that would signal, you know what, I'm actually comfortable with certain kinds of personalization on this site. It would be a technical measure, if this were to be worked through, that would allow, if you will, a technical one-stop approach to working with the e-privacy directive. That's a sort of attractive vision. There's been support, again, from DPAs, from a variety of sources in Europe. We've been meeting on that this week, and we expect to have further meetings, probably in Berlin, probably in March, with an in-person meeting. But there's efforts to build this global standard, if we can, that will be built in once and understood broadly. There's many implementation challenges, but we hope we have a lot of people working on the process who are going to be effective at making it happen, and we'll see what we're able to do. Thank you.
Thank you very much, Peter. It's my pleasure now to introduce Sophie Narbonne with the CNIL, which of course is the French data protection agency, and the CNIL has taken a significant leadership role among the European DPAs on a whole series of issues, so I imagine you'll tell us a bit about that.
Thank you very much, and thank you for inviting the French DPA as giving an example, a very modest contribution to this panel. I must say I was quite thinking that Suzanne gave a very good ouverture of what I was going to say. In France, we have much less experience in multi-stakeholder processes, but we are aware that not only they are valuable, but they are indispensable. But we think that they are indispensable on top on the legislation and not replacing it. Just to give you some very concrete examples. You was speaking, Peter, just now about the directive, the e-privacy directive. I can tell you that if the express consent of the internaute to receive cookies was not in the directive, it would have been impossible to speak with all the stakeholders. I'm thinking about the industry, as we are doing at the moment with them to find means of implementing this opt-in mechanism. And the same rule has to apply to everybody. And what we think is that with the approach, the voluntary approach, not only is not enough, but could be very unfair, because it's only companies being of a good intention who could be sanctioned. And what about the others? So we think that really this legislative basement is fundamental. And why fundamental? It's because of this distinction very clear between the European approach, speaking about privacy as a fundamental right, and not only as a consumer right. So this difference of approach doesn't mean that there is no link, because of course we are more and more conscious about this necessity to cooperate. And at the moment, one of my colleagues is speaking about the binding corporate rules, and we are dealing, there will be some discussions going on with the Department of Commerce about the interoperability with the CBPR, the cross-border privacy rules on the APEC side. We are thinking about reinforcing with the FTC the international cooperation, and I think we have to be optimistic. But really, we believe that on such a subject in a numeric world. Only the law can give this and assure for the residents, all the citizens. It's not only an industry matter, but a choice of organizing the society and to give as much rights to the citizens and residents as in the real world. That's just a few words, and we will be elaborating later.
Thank you. Finally, it's my pleasure to introduce Christina Irion, the co-chair, and also a person who studied the privacy issue, I would say, from both sides of the Atlantic, now associate professor at Central European University.
Thank you very much. We want to now steer the debate a little bit in the various elements to compare the approaches in the US and in Europe. And I would like to just add shortly to Ms. Narbonne's observation that we also know, of course, codes of conduct in our EU regulatory framework, but that the approach is co-regulation. That means that such a draft needs to be approved then by the appropriate bodies. And the question that I immediately think of now is how these various efforts on both sides of the Atlantic later are going to tie in with each other, and how the approach that we pursue here in Europe for codes of conduct and the one that we pursue in the US are later producing some coherent results, since we are living in a very interconnected world here. I would like to give this question to Commissioner Brill, please.
I'm sorry, could you repeat the question?
How do the co-regulatory approach in Europe for certain sectors to draw up code of conduct interoperate with the efforts that we are observing now in this multi-stakeholder process that is proposed in the white paper from the White House on privacy?
So if I'm understanding the question, the issue is, how would the multi-stakeholder process work and how would it enhance interoperability? The multi-stakeholder process, the key to it from my perspective, again, as an independent law enforcement agency, is that there are promises that would be made to by industry to comply with the codes of conduct that are developed, and those promises would be enforceable. And they are enforceable by us because the failure to live up to a promise would be considered a deceptive act. I've traveled through Europe quite a bit, and in Germany and here and elsewhere, and I think there's a bit of confusion about the authority that the Federal Trade Commission uses in order to enforce privacy promises and also to enforce against unfair practices relating to privacy. Our law, so I'll say that, a majority of the commissioners, myself included, do support a broad-based privacy law in the United States. We've come out and we've said that it would be helpful to have, for instance, a requirement that says on a national basis, companies must have a privacy policy and must describe what they're doing with consumers' information. So, but I should also note, as a slight digression, states also in the United States have a great deal of authority in this space, and the California Attorney General's office is actually moving in a very appropriately aggressive way to enforce a California law that requires privacy policies to be in place. And we all know not only is much of the industry located in California, but of course all of the folks that are affecting California citizens would come under that law. All the industry that's affecting California citizens would come under that law. But, so I do think a broad-based national, federal U.S. privacy law would be helpful in a number of different areas, and we've called for it. Having said that, the Federal Trade Commission Act is actually quite broad, and it would be surprising, I think, to most people to see what it is that we can do under that law and the kinds of activities that we can reach. So in addition to the deception theory, that is, if you make a promise that you're going to abide by a multi-stakeholder set of principles and then you fail to live up to it, we go after you. I mean, that's the same theory that we use to enforce the EU-US safe harbor, and we've done so to great effect over the past couple of years. But in addition to that, we also have the authority to go after unfair practices. So I kind of reject this, what I understand to be this notion of co-regulation, which is that unless you make a promise, you're not subject to any sort of enforcement in the United States. We do have our unfairness jurisdiction, which is extremely robust. There are people here in this audience, Barron is one of them, there are others, who think that we should actually be more active in using our unfairness authority. And frankly, Barron, I agree with you. So, you know, it's not just if somebody makes a promise, then we can go after them, but we can also look at practices that are fundamentally unfair. Now, the other thing I just want to address really briefly, and then I'll put the mic down, Susan and others, and Kristina have mentioned, and of course, my friend from the CNIL have mentioned, you know, it's not just in the commercial context that we need to be thinking about privacy, but also its citizens' rights more generally. Well, the Federal Trade Commission is set up, just for those of you who may not be as familiar with us once again, we're set up to focus on information use in commerce. We just don't have jurisdiction over government use of information, and I understand there'll be another panel to talk about that. So it's just not our remit. It's just not what we do. We focus on what businesses are doing, and so that's why I am focused like a laser beam on those kinds of practices.
Thank you very much. Now, when we see that do not track as a global standard, how will then the various efforts that are happening in the multi-stakeholder process in the United States to draw up voluntary codes of conduct tie in or can be streamlined with other similar efforts in Europe? How do you envisage this process of connecting across the Atlantic? Thank you, Mr. Morris.
Sure, thank you for the question. Let me just make very clear that we don't view the multi-stakeholder process that we're helping to manage as an American-only process. I mean, we are absolutely welcome European participation, whether it's European companies and global participation, not just Europe, but your participants from Europe, your participants from European DPAs, and so I mean, from our perspective, the codes that we are hoping will come out of our process, we think will in fact be able to benefit folks all around the world. As to how this interacts with the do not track process, it's entirely compatible. In terms of the legislative proposals that we have had, we certainly are quite supportive of multi-stakeholder processes that are initiated by the government, which is what we're doing, but also multi-stakeholder processes that are initiated, by private parties, as the W3C process is. And so really, I think that they can be completely compatible. We do support having baseline privacy legislation in the United States, and that would enable the FTC to enforce some of these privacy rules even without the multi-stakeholder process. But in the absence of legislation in the United States, we think the multi-stakeholder process and the W3C process, the do not track process, can make some significant contributions to improving privacy protection both in the U.S. and elsewhere.
Great, thank you very much. We're going to take questions now. So if you would like to ask a question, and is there a person with a microphone? Thank you. So why don't we go to the front first? And if you could identify yourself. Of course, it's a privacy conference, so that's not a requirement. You can be anonymous if you wish.
Hi, Mark. Alexander Hanf here. A question for Julie Brill. Given the powers that exist for the FTC, when are we going to see some real action against actors such as Facebook and Google, rather than these slaps on the wrist we keep seeing for the many breaches that have happened over the years?
I believe we've taken real action against Facebook, against Google, and against many, many players in the ecosystem. You know, it's one thing to sort of sit back and criticize the dollar amounts that we get, for instance, when we enforce our consent decrees. With respect to Google, we obtained a $22 million penalty. Now, I understand that people have sort of compared that to their market capitalization and to their revenue on a per day, per year, whatever basis. I don't think that's the right measure. I think the measure is, how does that penalty compare to other privacy enforcement work that we have done? And it was the largest penalty that we had ever obtained in a privacy case. So to us, that was extremely significant. Look, I've been talking to folks at Google over a number of different issues lately because, again, we do competition work as well as consumer protection work. They take extremely seriously the orders that we have in place. The other issue, though, that I think everyone needs to be aware of is when we are enforcing our deceptive and unfair practices law, just the general law, as opposed to, for instance, COPPA or the telemarketing sales rule or the do not call list, all very, very important laws that we do enforce. But using our general unfair and deceptive acts and practices jurisdiction, we do not have the ability to penalize until someone violates a consent order. So we needed to get the Facebooks of the world, the Googles of the world, as well as all these other smaller players under a consent order where we, they last for 20 years. They have to have a comprehensive privacy program. They're audited every other year. I mean, these are very significant consent decrees. If those are violated, then we can get the penalties, and that's what happened in the Google case. So a short way of answering your question, I think we have very significant real orders in place for the most significant players, as well as the players, some of whom nobody has ever heard of. I mean, we haven't talked about data brokers yet. Data brokers are an extremely important sector because they're not consumer-facing. Consumers don't know about the activities that are underway with respect to the data broker sector. This is an extremely important area where we have been actively enforcing and where we have also called for legislation so that there's much more transparency with respect to consumers. But I think our enforcement actions are real and are effective, and we're going to continue to do it.
I'm going to just take the prerogative of the chair for a moment because the complaints to the FTC regarding Google and Facebook were both brought by Epic in association with other consumer organizations.
Yep.
And those matters were settled in 2011. It's now 2013, and I just want to be sure that I understand that the FTC has taken one enforcement action against those two companies since 2011. Is that right?
Well, you're talking about in the privacy space.
Yes.
Because we obviously have another whole competition order against Google, which, so the short answer to that question is that's not the only enforcement work we've done against Google. We have done other enforcement work against Google, but with respect to privacy, if I'm recalling correctly, Marc, as you know, our orders are first proposed, and then because of the transparency that we engage in vis-a-vis the public is allowed to comment on our proposed order. Both, if I'm remembering correctly, both the Facebook and Google orders were not finalized until 2012. And we very quickly, after the Google order was finalized, then engaged in an enforcement action with respect to the Safari activity.
Okay. Next question, please.
Yes, hello. First of all, I'd like to thank the organizers for putting up such an excellent panel. It's very good to see you guys up here and giving us the possibility to discuss with you and to strengthen this exchange. My name is Jan Schaderbeck. I work for a German data protection agency, and I had the pleasure of co-chairing a workshop on Do Not Track and Beyond last November on invitation of the W3C. And my question goes to you as experts in the multi-stakeholder and standards field, and I've been working in standards as a vice convener to a working group in ISO for the last 7 years, and it's my experience that there's limits that to what multi-stakeholder approaches and standards can do, and that very much relates to what Susan just said. And DNT may be an excellent example for this, to that extent that DNT is not only a technological solution to a technological problem, but it will have losers and winners in the end. And maybe DNT is a very excellent approach. It may be 10 years late. Similarly, the cookie directive is an excellent approach. It's 9 years late, plus it's not enforced, which is a huge problem. So the problem I see when discussing DNT in Berkeley last year was that it was my impression that when you have losers in a consent-based procedure, that is going to be a tough call. So it's my experience that you first need a clear regulation, and then it may be you have a situation where a win-win situation for all those stakeholders at the table by finding a joint solution on how to implement the regulation, be that via standards or agreements. But if there is no regulation, there's very little incentive for those who are going to lose to actually opt into that. And that's the struggle we're facing with Do Not Track, and that's why it's even taking longer after it's already 10 years late.
So this is an important point, and I think maybe the question would go to Peter. And it's really the distinction between a multi-stakeholder process that shares a common goal once a regulation is in place, and a multi-stakeholder process that's established without even a clear objective. Do you see that distinction? Does that concern you?
Well, I've been at the W3C since late November of this year, so I'm still learning some of the things, but I've been around these issues for a long time. One of the things that happens in EU-US discussions is a concern from the European side that the US has not passed legislation. And nobody at this table can pass US legislation, right? The Obama administration has come out in favor of such legislation. Commissioner Brill and a majority of the FTC commissioners have come out in favor of that legislation. But that doesn't get the Republicans in the House of Representatives, for instance, to pass the legislation. So part of what happens is we live in a world where, given some constraints, we try to figure out what we can do. Or at least that's part of what I do. And so part of Do Not Track has some virtues. It has the virtues of having a lot of the relevant people talking about the same issues. It has the virtues of focusing attention on some practices that are really not very defensible once they're made public. It has the virtue of having people from Europe and the United States and elsewhere talking together about these things. And it has the virtues of clarifying, for instance, for websites and for advertisers, as many civil society people have said during the discussions, if the practices are not good at the level of what industry is doing on the web pages, there are technical countermeasures that can be taken. They could be taken by browsers. For instance, Safari blocks third-party cookies. For instance, Microsoft did a setting on Do Not Track that made a lot of people in industry quite unhappy. But beyond that, users can also put in ad-blocking software and other things going forward. And so one of the hopes for W3C is that rather than having a technology war between users and websites, that we can get to some agreements about practices that will get implemented. How to get there is not easy, but that's at least the theory of the case.
Oh, I think we have time for a few more questions. Peter mentioned the Microsoft controversy surrounding Do Not Track. I was interested in that, actually. My recollection was that Microsoft had concluded to take a strong privacy default for online advertising, and they were immediately criticized by many of the participants as violating the process, which seemed a very interesting critique, because now it was the process of multi-stakeholderism that was prevailing over the goal of providing some online privacy, but this is just my personal commentary. Okay, our question, please.
My name is Haruo Takasaki from Japan. So I have a question with Julie Brill. So in the morning session, there is a discussion about meaningful consent. So Dr. Schwartz in last December at Harvard Law Review Privacy and Technology Conferences, he wrote about consent, notice consent paradox. So the consent mechanism in the United States doesn't work well. So how about the discussion now, FTC, how to proceed?
Thank you. I was unfortunately not here for the presentation this morning. We've spent a lot of time working on the consent issue. That's what you're asking about. Our agency has been, and I in particular, have been very concerned about the long, legalistic privacy notices that consumers, click here and supposedly they've read it, and we all know that no consumers read it and no consumers understand what's happening, and does this give carte blanche to companies to then do whatever they want with consumers' information? There's been a lot of concern on the part of the Federal Trade Commission and myself in particular about that phenomenon. And we have called for much more effective notice and consent in this area. So for instance, one of the things that we are calling for is layered notices. That is, giving consumers just enough information to let them know that something's happening and where they can go to get more information if they want it. We also talk about just-in-time information, so that before their geolocation information starts to get transferred to an app, they're told on their smartphone, geolocation, this app wants your location information, is that okay? So it's very, very important that we start to be thinking about more effective ways to communicate to consumers. A third issue that we've been advocating for and looking at very closely is the use of icons. When you're in the mobile space, which is of course extremely important, as I mentioned, it's going to be one of our big focuses going forward, real estate is very limited. You only have a very small amount of room. Icons are going to be a key factor to starting to communicate to consumers much more effectively what's happening to their information. So we had a workshop, we had a workshop a couple of months ago all about disclosures and how they can be much more effective, much more effectively done. We're going to be coming out with a couple of reports. One will be on the mobile disclosures in particular, and then another will be a broader set of disclosures. So this is a very, very important issue. I do think that a lot of work needs to be done in this space, but I also think that there are a lot of entities, both consumer groups and industry groups, that are working hard because everybody realizes it's an area that needs work.
Thank you. I wanted to give Susan an opportunity to comment. I think actually your question goes to a deeper concern about notice and consent, and maybe Susan could speak to that.
Well, we don't really have a consent regime in the United States, with some, maybe a couple of exceptions, such as the parental consent that's required in the Children's Online Privacy Protection Act rules. So we just, and we don't even actually have a national notice requirement. The problem with notice is that A, people are never asked for their consent, and B, academic studies have shown that people are actually misled sometimes by privacy notices. They think that it means that their information will be kept private when in fact it won't. We were amongst a group of consumer organizations in 2007 that called for the Do Not Track tool precisely because we wanted an easier way for consumers to exert their wishes than they have now. I have to hand it to Peter for his willingness to walk into the lion's den, because it's really a very hotly contested idea that consumers should have even a do not track signal that they can turn on, let alone Microsoft's very brave idea of turning it on by default. Industry is just opposed to all of this.
Thank you. I also wanted to give Sophie a moment to speak about the current investigation.
Yes, because when you're speaking about Google, perhaps that you know that the CNIL is driving on behalf of all European data protection authorities an investigation on Google's new privacy policy. And we are waiting for the information that Google have to give to us before the 15th of February. as after several months of investigation, we established some lacks and infringement to the directive, speaking about incomplete information, uncontrolled combination of data, no information of retention periods. So we are really determined to go very far on those subjects.
Thank you so much. I think our time is at an end now. I would like to thank our panelists for really interesting discussion. Thank you.
Thanks, Marc.
Thank you, Marc.